A foreign substance is something that is not supposed to be on the floor of the premises. To recover for a slip and fall on a foreign substance, the plaintiff must prove 1. That the injury was caused by a specific act of the defendant which created the dangerous condition, or 2. That the defendant had actual or constructive knowledge of the dangerous condition and failed to remedy it. These cases turn on this notice requirement and are often won or lost at the summary judgment motion stage. If the defendant created the dangerous condition, then the defendant was actively negligent and can always be held responsible for creating the hazard. Otherwise, we must show knowledge of the condition, which is usually based on a theory of constructive knowledge of the hazard. A plaintiff must prove that the foreign substance had been on the floor for long enough time that the store should have known of its presence and removed it in order to show constructive knowledge of the hazard. It's often very difficult to prove how long something was on the floor. Whenever you have a slip and fall that involves foreign substances, we need to determine if employees were in the area of the fall and could have easily seen and removed the hazard by deposing these plaintiffs during litigation and establish their location in the store. It is important to get testimony about the location of the employees in the store and their line of sight to see these foreign substances, as well as any color and size of the substance. You must also determine if there were sweep cards or inspection logs that show when the area was last inspected by any employees. Store surveillance videos are the absolute best way to prove who was in the vicinity of the hazard at the time of the fall. When was the last time the area was inspected, or even how long the substance was on the floor could all be shown by this video evidence. Most stores keep surveillance videos for a period of time before writing over, so we need to send a spoliation letter as soon as possible at the beginning of the case to make sure these videos are preserved. If they fail to preserve a surveillance video after receiving our letter, that can subject the store to various sanctions, including even getting their answer struck. Now, surveillance videos can also be used by the defense to prove that they are entitled to summary judgment. So the eye in the sky doesn't lie. You've heard that before. These are difficult cases, so call us to review your set of facts, 843-839-4111.